We remember back 2 years ago when they started confiscating force reset triggers. You got your nasty gram in the mail that said, ooh, having subpoenaed and confiscated all the records of people who sold these, we see that you bought one of these force reset triggers. Guess what, sucker? It's a machine gun. Give it to us right now, or we are going to prosecute you, perhaps.
We are the Armed Attorneys. Today we're talking about an important update when it comes to machine guns. What's the latest with those? We have a new decision when it comes to FRTs, to force reset triggers, and we've gotten some questions, so we wanted to talk about how this might impact the Matt Hoover case. We're also going to be talking about that. But before we begin, show your support for the Second Amendment by hitting that like button. Now, machine guns, FRTs, Matt Hoover, I think in order to I kind of want to start with Matt first. So what's going on with him?
Yeah, and we've gotten basically, I mean, starting with the bump stock saga, we had people commenting pretty consistently, how does this affect Matt Hoover's case? And it's a good question. Anytime we see anything that touches the idea of what is a machine gun, I think it brings that issue to mind. So Matt Hoover, and this is just the 60-second version. We have past videos on this. You are welcome to go check out. We'll link them in the description. We had Matt Hoover along with Irvin.
Yep.
Selling these auto key cards. So we had little pieces of metal. We had just the outline of what could have been, should you have evil in your heart and ill intent to violate the ATF's regulations and laws, could have been milled out to become an autoseer. Now,
theoretically, if they were in specifications.
If they were in spec, which, boy, the ATF sure had to engage in some shenanigans to make it happen, but shenanigans they did. So what we have is what was, I think, at its heart, a First Amendment issue, prosecuted as a Second Amendment violation of the NFA, of criminal law.
Yeah, and just for additional background, we have a general prohibition on the possession of machine guns, and what the federal government considers a machine gun is a single part.
Yes.
That is exclusively used for machine guns, or you have a combination of parts that's for machine guns.
And that's statute, by the way. That's not ATF regulation.
No.
That is the criminal law enforced in the United States Code.
Yeah, what
part or combination of parts.
Yeah, what adds confusion to this is the redefinition of machine guns to sweep up bump stocks, to sweep up FRTs, and I don't think they're relying on the change in the definition by the ATF when they were looking at Matt.
No, so we've got just that actual, I know because everybody's already starting to type, rules aren't laws. This is not the rule. This is actually the law under which this prosecution has happened. And, we have also, in addition, really, they went after them on the conspiracy issue as well, right? Like, you conspired to transfer these unlawful NFA items, people. You knew what they were. You knew what people were going to do with them. It was already an auto seer. It was already a machine gun.
How could they possibly prove his intent?
Excellent question.
Doesn't implicate anybody on YouTube.
I was getting the cold sweats when we were following this case because, oh boy, that prosecution went through and watched every YouTube video and pulled just tiny side comments everywhere about maybe this is a gray area. They might come after us for this. And little comments about don't blah, blah, blah with a wink and a nod, and just things that are, it's still not intent. It still doesn't prove intent. But oh boy, Richard and I can never, ever break the law.
No.
Can never break the law because...
Yeah, really tied our hands on this one.
Yeah. I mean, not that I was planning on it, but woof. So it's scary. Matt Hoover was, and his co-defendant, we're really focusing on Hoover at this moment, convicted by a jury in federal court in Florida of many of these charges upon which he was indicted. He was sentenced to 5 years in prison, and the case is, in fact, on appeal right now, but not much is happening yet. Where are we on the appeal?
So, Matt, right now, it is still early in the appeals process. They have got docketed back in September of last year, and in this past May, the court granted their motion to exceed the word count in their brief.
Yeah, so the briefs have not even been filed, and then the briefs have got to get filed by both parties, and then maybe a reply, and then the court's got to consent. I mean, honestly, this appeal might not be finished until he's released.
Yeah, his projected release date right now is May the 9th, 2027.
Like, what are we, mid 24 right now?
Yeah.
If this appeal is decided at the end of 2025, I would be pretty nonplussed by that. I think that that is probably the timeline.
Yeah.
Which is crazy.
Yeah. So, all right. So Matt comes back up because machine guns are back on the news with a fantastic decision when it comes to forced reset triggers. And so Matt comes back up because we have a new decision when it comes to FRTs, force reset triggers. If you want to check this case out, this is National Association for Gun Rights v. Merrick Garland, case number 423-CB00830. And this addressed our new standard by which we look at rulemaking by agencies. So this is the Loper Bright Enterprises case. We'll link that in the description below. This is the case that should have a tremendous effect on reining in the administrative state. And we have our test in Loper Bright. We say, has Congress delegated this authority to the agency? Did the agency act within the scope of, what has been delegated? And then, we take away agencies basically giving themselves their own rulemaking authority, and they get to decide whether or not their rules fall within whatever Congress provided. It was a nightmare test. That's the Chevron deference decision. So they said, guess what, ATF? You exceeded your authority. You were not delegated the ability to define and expand the definition of machine guns.
Super. And I mean, this was coming. I mean, as soon as the Cargill case came down too, this was coming, which was just a week before Loper Bright. But because that made very clear, like, this is what a machine gun is. You can't just regulate your way into something that's not a machine gun being a machine gun. So, I mean, we take those Supreme Court decisions, we look at force reset triggers, we remember back 2 years ago when they started confiscating force reset triggers, you got your nasty gram in the mail that said, ooh, having subpoenaed and confiscated all the records of people who sold these, we see that you bought one of these force reset triggers. Guess what, sucker? It's a machine gun. Give it to us right now, or we are going to prosecute you, perhaps. And lots of people, right? I mean, at the time, I mean, there was no decision saying it wasn't a machine gun. So it was destroy it, give it up, get it out of your possession, because otherwise you are risking being prosecuted for being you're risking a Matt Hoover type prosecution, right?
Yeah, and unlike, think about the arm brace decision where, the brace being on the rifle, transforming it. Again, this is all theoretical and this isn't the law now, and we have a good decision on pistol arm braces not being considered short barrel rifles. But for a period of time, they were saying, hey, guess what? If you attach a brace, this is a short barrel rifle and needs to be registered. And we could separate those items and just take it off, and you're complying with the law. What made bump stocks and forced reset triggers so different is just the part by itself was the machine gun. And so there was the remedy, or theoretical remedy, to make sure that you weren't breaking the law was much more extreme.
Right. If I had a full auto sear and I wore it around my neck like a necklace, I would be in unlawful possession of a machine gun, and the federal government could put me in prison. I mean, that's the difference between the machine gun law and anything else, right? Is that it is simply the part that makes a machine gun, or combination of parts, right? So we have this fantastic FRT decision that came down July 24th of 2024, where summary judgment is granted in favor of the plaintiffs.
Flavor of the month is freedom.
But so in favor of the plaintiffs, and the ATF is ordered to stop doing this, to return all of the FRTs they have confiscated. Fantastic. Of course, the federal government will appeal it, as they are wont to do, but I don't see freedom losing down the road here.
Permanently enjoined from enforcing it.
Correct. So that brings us back to our ultimate question here, which is, we've got these great decisions and we've got Matt Hoover sitting in prison. What effect does all this have on Matt Hoover?
I think it's more limited than maybe we want it.
That, yes. And just like big, like flashing caveat on the screen here. Everything I'm about to say that is going to enrage you is not the way I want the world to be. It is simply my realistic prediction for what will happen. What I want to happen is to take a time machine back and have the federal government and the AUSAs never prosecute Matt Hoover in the first place because he didn't do anything wrong. I can't make that happen. So what we've got here, and the problem we've got here, is that we have Matt Hoover convicted by a jury on ultimately what I think the government is going to be able to successfully argue was a question of fact within the purview of the jury.
Yeah, and so the entire judicial system is designed to uphold jury verdicts.
Uphold verdicts.
In the very rare circumstance where they do not uphold a jury verdict is what we call basically the no rational jury standard. No rational jury could reach this conclusion, and that is an extreme remedy that is very rarely used.
Yes. And so I do not see this being such a case. So this is the issue we have here. We don't have is a bump stock a machine gun? Is this new definition that the ATF has imposed in the Code of Federal Regulations lawful? We have the statute, the thing that's actually hard law. Was it violated or was it not? And so, like, if you put it on a spectrum, I love spectrums. So if you put it on a spectrum of like, you have a Hallmark card upon which you have drawn an auto sear, right? Versus actually selling a milled out, ready to go auto sear, right? Definitely a violation of the law. Never going to be a violation of the law. You have this thing, right, that Matt Hoover is accused of, which is distributing these cards upon metal, which theoretically could have been milled out, theoretically could have worked, even if it took lots of shenanigans for law enforcement to make it work. Is that thing expression, art, First Amendment, or is that thing the violation of the criminal law? And the government's argument here is going to be none of these cases that have come down matter. None of them affect what the jury decided as to whether or not that line was crossed as to a violation of criminal law. The jury said, yes, here we are. And I hate that, but do you have a different opinion?
No, I agree with that analysis. And I think we're obviously going to be following this case. When we see the initial brief on the appeal, I'm interested to see what issues his trial team are going to think, are the lowest hanging fruit or the most likely to succeed. I mean, that's usually what you do. Look at a case, see where the errors are, find out where, there are the biggest opportunities or chances of success. Without having that briefing, I have a couple of ideas. I'm sure there's some Second Amendment arguments in there.
I think there's a due process argument.
And there's a due process argument. Yeah.
They've made that, right? They made that in a prior filing, but I think it's the vagueness argument is a good one.
Yeah, I think that's a great one.
Part and combination of parts is too vague for Matt Hoover to have known what he was doing was a violation of law. But then that's where the government comes back in and says, but he said this thing here and this thing here and this in this video that all indicated that in fact he knew he may have been violating the law. And that's why we can't break the law.
No, but best wishes to Matt, to his trial team. I hope everything, I hope they have some success on the appellate level, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question and comment for us below. We made this video because you asked for it, so we do pay attention. Tell us what you want. Until next time, we're the Arms Attorneys.